Damien Geradin, very warm welcome to Digital Markets Research Hub. I was looking for this conversation for a long time, and I'm very glad that you have accepted the invitation. You have contributed to a very interesting, engaged panel on when the DMA was just at the big infancy, so to say, and now we have opportunity to look at the DMA at this one of the most important milestones when the compliance reports are expected to be released. And you know the regime like not many people do, because not only you are engaged lawyer representing different parties in these discussions, you're also a prominent academic. But in addition to all these well-known features, it's really impressive how you have engaged into the technicalities at the very outset, trying to unravel this complexity about different core platform services, the substance of them, and combining it with prominent legal mind. It would be a great opportunity for us to learn from you. How do you understand this whole process? But my first question about the DMA is more general. So how do you evaluate the final product from legal perspective mainly? Is it something which could be improved in principle? Is it something which you are happy with? What is your view?
Yeah, so first of all, thank you for inviting me to speak. It's always a delight to exchange with you, Olesh. As to your question, I mean, I think the DMA is a good piece of legislation. It doesn't have any major flaws. I mean, obviously, you can always improve things, but I'm generally quite satisfied with the final product. Maybe one potential weakness that we're seeing now is that there was no real time frame or space for market testing. Okay, so basically, the parties, the business users, and maybe the associations of users as well, have never been given an opportunity to make comments on the forthcoming compliance programs of the gatekeepers. So, for example, Apple released what looked like a compliance program, but it came entirely unexpectedly. It would have been better, in my view, if Apple had shared it with the Commission in advance, which would have allowed the Commission to share it with business users so that they could have given feedback. So that's probably one of the weaknesses of the DMA. But overall, I think that it's a good piece of legislation.
But would it be reasonable to hope, at least, that this compromise has been done to speed up the process? And because the process is annual, the compliance reports are expected to be released on an annual basis, maybe the previous year would be a kind of market test in practice, or you would expect something more mature and more scientifically sound?
No, I mean, I realize that there are all sorts of constraints and time is one, okay? I think we have to admit that it's a new regime, so it will have infancy issues. That's almost unavoidable. But still, I think that giving a short time window to business users to comment on the pre-final version of the compliance program would have been useful. But it is what it is, and I think once we see the compliance program, it will still be time to make observations about it.
And we see many voices at the beginning, we have seen them, hoping that the DMA will somehow reshuffle the entire structure of digital markets. And there were more pragmatic people who were saying that you have to apply, it's comprehensive, but you cannot apply it comprehensively. The Commission has to select priorities for various reasons, and that the catalog of obligation, the fact that the obligations are not harmoniously listed, they are not necessarily, they're just copy-paste in the previous experience, let's say. It's not a shortcoming. It's like it gives you a variety of tools which you can select depending on the priorities. You have identified several pitfalls from the very outset, like the issues related to GDPR and the consent how
Yeah.
easy it is to get the concept. So I wanted to hear your view, or to ask your view about different, quite eclectic core platform services. Which one, in your view, and obligations related to this core platform service, which obligations, in your view, should be given priority if we face the need to make priorities?
Yes. So, I mean, I think that we're not dealing with competition law, right? We're dealing with a piece of regulation, effectively. So in competition law, the theory and the practice is that the Commission and other competition authorities will pick priorities and they will decide to enforce the law in a given sector, on a given issue. Here, in theory, you know, gatekeepers should comply with everything, right? I mean, there's no, it would be a pity if the Commission decided, well, you know, I think they can get away with 50% of it, and as long as another 50% is complied with, right? So priority setting is a bit different. Now, in reality, the Commission has only so many officials, and it will not be possible for them to engage in 10 parallel infringement proceedings, assuming, of course, that there are so many problems that 10 parallel infringement proceedings would be necessary. Okay, we haven't seen the compliance program, so we don't know yet. We're just so Apple. So I believe, and I think the Commission is quite transparent about it, that it will have to pick some priorities, okay? And then try to resolve issues bilaterally with the gatekeeper, and maybe the gatekeeper will be willing to make some extra concessions or to clarify some points, but I suspect that in some cases that will not be possible, okay, because the gatekeeper will be entrenched, they may have their own red line, and therefore the Commission will have no choice but to open infringement proceedings, okay? I don't know if the priorities should be set by provision or by core platform service or by sector. I think it very much depends from what we will see on March 7. And by the way, we may not see anything on March 7, because I suppose that the gatekeepers will send their compliance program by then, and then the Commission will look at them, and it will take some time before they come to the surface, right? So we all say March 7, but we may not have anything to look at on March 7, maybe March 20 or April 7, who knows? And I think that once we see that, I think it will become clear where the big problems are, okay? I think one big problem, and I've already written about it and commented on it, is the App Store. I believe that from what I see from the Apple announcement and related documents, they're not complying with the DMA. So it would be number one on my list. And I think it's almost unavoidable, given Apple's attitude, that they will be the first, or at least among the first, infringement actions. And then I don't think we've seen enough from what Google, Amazon, Microsoft, TikTok are doing to decide whether they're a priority or not. I can see one priority, and then I think we need to see what they deliver by March 7 before saying, oh, the Commission should do this or the Commission should do that. I think it's too early. I think the Commission will also want to focus probably on what is most impactful, okay? So maybe deal with the provisions or the core platform services that are the most important, that deliver the most benefits in terms of business users and users. Now, I'm not privy to their, to their approaches or policies. They've not commented on that.
And on your earlier part of the answer, we hope that we will have this summaries of non-confidential summaries of the report, because or one of the indirect evidence is the Commission scheduled already individual stakeholder workshops on each designated gatekeeper by the end of March. So
that is true. That is true. Now, I think one question will be whether these summaries will provide enough information. I think there will be a temptation on the part of the gatekeepers to be quite short, okay? And there might be some back and forth between the gatekeeper and the Commission, with the Commission saying, sorry, by summary, we didn't mean something that is so short, right? And so devoid of substantive information. Again, it's a new regime, so I'm not sure what to expect.
The new regime, and we understand that all these open-ended adjectives or nouns, fairness, contestability, fair, contestable, will be in one way or another fine-tuned. The length of the string will be measured and established by practice, guidelines, case law, etc. So we are in a unique moment where these parameters are being in the process of crystallizing. Yeah. So what would be your recommended optics for the Commission? How should they perceive these two open-ended provisions? What should be their broader kind of goals with this regime?
I mean, look, as you say, there are two distinct objectives. One is contestability and the other one is fairness. They're quite different in nature. And I also think that there might be different legal avenues for each, okay? So let me give you an example, and I will often refer to that because this is the only compliance program we have seen so far. So one of the objectives of the DMA provisions as they relate to app stores was to create more competition in app distribution, okay? So there were two ways to do that. One was to allow side loading, and the other one was to allow alternative marketplaces, okay? Well, Apple is not allowing side loading, not at all. And they formally allow alternative marketplaces, but it will be very difficult for these marketplaces to take off for various reasons on which I'm happy to elaborate. Another objective was to increase competition in payment solutions, right? So that it would be possible for app developers to provide a link out to purchase or to use an alternative payment solution. Whether Apple delivers that is an open question. I don't think so, but others may think differently. There, I think that the Commission will want to make sure that the objectives that are in fact transcribed in fairly specific provisions are complied with, okay? And if they consider that these objectives and the provisions implementing these objectives have not been complied with for a variety of reasons, they will want Apple to do better, okay? And in the case of an infringement proceeding, Commission will have quite a bit of leverage to make this happen. If you think about fairness, things are a little bit more complicated because you look at Article 612, which is the so-called friend provision. Well, then you could say, well, Apple is charging this level, this percentage in terms of fees, and this is not friend because it's not fair and or it's not reasonable. I'm not sure I would see the Commission saying, sorry, 17% is not correct, it should be 14%, okay? The Commission and competition authorities generally are not keen on making these decisions for all sorts of reasons. So there, maybe another route would be for the aggrieved parties to go to court and ask for a judge to set a friend rate, which is what courts have done in other areas of the law. So, you know, we may see the Commission focusing, perhaps, I don't know, perhaps more on provisions that relate to contestability, while leaving fairness issues, and in particular, the determination of price or rates, to courts.
And the temptation was to make a shortcut, as UK regime did, Canada, Australia did for slightly different purposes, but the rationale of something which in the UK parlance or in the UK DMCC Act is called final offer mechanism, where we delegate this to kind of speed fast lane and do it much quicker within kind of internal arbitrage mechanism, so to say.
Yes.
Do you think the temptation, the Commission was considering this option when drafting the DMA, or it was something too ambitious?
It's not in the DMA. Now, it's a fairly effective way to deal with these questions, right? Because it's quite radical. In fact, if you think about final offer arbitration, that means that each parties make an offer, and the court or the arbitrator has to pick one of the two, right? They cannot shoot in the middle. They have to pick one of the two. The result of that is that both parties have to be reasonable, because if one is clearly unreasonable, its offer will not be picked. So I think I like that approach. It has many merits. But to the extent it's not written in the DMA, I suspect that gatekeepers will resist that approach from being pursued. Now, one court may decide to follow that approach. I don't know. We don't have any case law. But indeed, but generally, I think that courts are better prepared, and they're sort of more suitable for these sort of determinations than a competition authority, although the European Commission is not acting as a competition authority, but let's say a regulator.
And when you were mentioning some examples where the priorities or how fairness and contestability obligations have to be interpreted through which pathway, I wanted to ask your view about some geometry. Is it more vertical? Are we talking about business, medium tech companies mainly, who should be the main beneficiaries of the new regime, or should we somehow, as European Union, as political entity, be at least mindful of the need of having horizontal entries into this entrenched, systemically entrenched core platform service? Is it even feasible? Should we just abandon this as some naive, idealistic, utopian hopes, or it's something should be somehow incorporated into broader strategic digital agenda?
It's a difficult question. I mean, I think we have to be realistic. Those who think that the DMA will, revolutionize and reorganize the sector are a bit naive, I think. What we can hope is to see some movement, right? I mean, we can hope that there will be a number of companies taking advantage of the opening of some ecosystems, but of course, it will depend on the compliance programs. And I think the Commission should be quite tough on these, right? I mean, if there is a provision designed to ensure more competition and the compliance program does not deliver it for various reasons, I think the Commission should act on it. So it's a little bit difficult to say what will happen going forward. I mean, I think that in some cases, existing business users will be better off. In other cases, they might be opportunities for entry. But again, I think we need to look at that on a sort of provision by provision basis in light of the compliance programs.
The new start, everything is tabula rasa in many respects. From legal perspective, we already see that some gatekeepers, or majority of them, have challenged the very fact of designation. Is it something unavoidable? Is it expected, and we just accept it as not even an externality, but part and parcel of the regime? Or we made a somehow mistake by designating delineating core platform service so strictly and making all this designation requirement ambiguous, however much we were trying to make them clear and pro-enforcement, apparently there is still room for challenging the most obvious, the starting point of the game. Is it bug or feature or part of the process?
No, look, I mean, you know, there's some choices were made for designation. You can always criticize them. There would have been other options. I mean, the UK approach is to use the SMS test. I think it has some merits. But look, the system is as it is, and I'm not entirely surprised that companies are seeking to challenge designation, because these are companies with large resources, they have shareholders, and therefore they will defend their interests as vigorously as they can. So that was to be expected. Now, we'll see what the court decides. I'm not particularly convinced by the challenges I've seen so far. I think they're long shots. Now, I think these companies will often try to see whether they can win, even if the chances are limited. It's not the cost of filing an appeal at the general court that will be difficult for them, right? I mean, so some of them are trying their luck.
Let me ask your legal view about the provision which apparently is not particularly new. It exists in other latest wave of legislation related to digital markets and beyond, foreign subsidies being one example, namely anti-circumvention provision. So I wanted to ask your legal juristic mind, do you think that however pro-enforcement we might be, the very rationale of this provision, while we understand the need for it, that they know 1,001 way to tick the boxes while not delivering what they expected. From legal point of view, isn't it a step too far, and wouldn't be the most that we somehow serve the room for legal challenge? Because essentially, while meeting the letter of law, you cannot be liable for not meeting the spirit of law somehow, or it's too creative interpretation.
No, I mean, I think these provisions are really essential, and they're essential. Why? Because you will have provisions in the DMA that are drafted in a given way, and sometimes they may be exploited by a gatekeeper to effectively not comply through various techniques. For example, one of the things, let's assume that there's an obligation saying, oh, you should let business users compete with you in a given market, right? And then the gatekeeper says, yeah, sure, but there is a list of 25 conditions that need to be met before they can compete with me, or before they can have access to this. And when you look at the 25 conditions, you see that some of them cannot be met in practice, right? Because they're very demanding, or because they're unwieldy, or for all sorts of reasons. So there's probably nothing in the provision that allows you to put your finger on 1, 2, or 3 of these conditions to say, well, they don't work. It will be a matter of, you know, looking at things in a very concrete way. And therefore, I think that, you know, article, for example, 13.4 and 13.6 are particularly helpful. I think the reason why sometimes compliance with this obligation will fail is because either the gatekeeper introduce friction, technical requirements that are quasi-impossible to meet in practice, or will scare away users because you have warnings, or because, you know, they have to you know, take 15 steps before they eventually can take advantage of the provision. Sometimes it can be linked to cost and fees. Okay, you can do that, but then you have to pay this amount. And so I think that needs to be looked at very concretely And I think the circumvention provision is certainly a route to tell the gatekeeper, sorry, maybe your compliance program formally or facially is in line with the provision, but you have structured things in such a way that there's no effective, it's impossible for the users and business users to take advantage of the provision. Okay, so I think we need to move to abstract to very concrete.
All right. We have to wait for the reports and summaries and the workshop and all this. But I wanted to, maybe you know already, you sense by engaging in this regime, with this regime on daily basis, do you maybe sense already your gut feeling how different gatekeepers react? Do maybe some are more prepared to somehow comply? You want to take something out of us, we are happy to do it in more collegial, collaborative way rather than getting antagonistic and trying to challenge every step. Can you provide your subjective exposition or intuition about this?
It's very difficult. Companies have different styles, right? So for example, Microsoft is typically more willing to play ball with the commission and regulators, and they have a more positive language. Apple has taken the opposite approach. If you look at their announcement, they're extremely critical of the DMA. They basically say, oh, it's an absolutely terrible piece of legislation that will create all sorts of security problems, privacy problems, and therefore we're offering two options. If you don't like it, and I don't think you should like it, you can stay under existing terms. And if you really want to benefit from the DMA, you can adopt the new terms, right? So it's a fairly confrontational approach. And to be honest, I don't think it was necessary or wise for them to be so negative about it, right? It's quite an aggressive approach towards the institution that will effectively enforce it. So yes, there are different approaches. I think also that the DMA impacts gatekeepers quite differently, right? I mean, obviously, a company like Google is pretty much challenged by the DMA because most of their services fall under one provision or another. There are other gatekeepers that seem to be less challenged. They're less exposed. So maybe the response will depend a little bit on that. But I think it's probably also a question of leadership in the company. At the end of the day, if the lawyers and the advisors are told, well, you have to fight it to the bitter end, well, I'm afraid that it's going to be a very challenging and difficult process. If, on the other hand, the leadership of the company says, well, we have to live with it, so let's try to make it as smooth as possible, well, then I think that things will be probably easier for all parties. But again, we haven't really seen the compliance program yet.
I wanted to ask you, Damien, two specific questions on different core platform services, which appear to be very important. Cloud computing, cloud gaming, more generally, and digital advertising. And let me start with the later one. It appears to be that digital advertising is ultimately this point where you convert your digital muscles into pecuniary monetary equivalent. So to say, so it's crucial. And you, as I said at the beginning, you bothered to look at the technicalities, to learn and to understand this complex mechanism, diabolic mechanism, how it functions. There are several areas, and it was very popular a couple of years ago with CMA, non-perform digital advertising market study, and some other initiatives. What is your sense? Do you think the regimes like DMA and DMCC will challenge the status quo? Should the status quo be challenged? And is there or maybe there are other ways to do it?
Well, I think it's a very interesting example of the interface between competition law and regulation. Because I think what's happening is that the Commission is investigating Google for its ad tech activities. There is an SO that was issued in June 2023, and the Commission has expressed its preferences for structural remedies. Okay, we don't know what these remedies will be, but there are only so many options. And a structural remedy means that Google will have to divest part of its ad tech stack. In other words, part of the tools that they have developed. Okay, so if the Commission goes with that, it will have very significant repercussions on Google's activities. And I think this is one of these cases where structural remedies make a lot of sense, because at the moment Google is acting on the side of the buyers and the sellers, and it's the exchange in the middle. So it's rather peculiar as a construction. The DMA has some provision with respect to ad tech. They're essentially transparency provisions. I think they're useful, but they will not move the needle. So there, I think the main response will be through antitrust intervention. We have the same in the UK, where the CMA is also investigating Google. And there will likely be a code of conduct. I think the code of conduct might be better able to deal with the issues than the DMA provisions, because the code of conduct can be quite broad in what it does, whereas the provisions in the DMA are quite narrow, in fact. What could potentially happen as well is to have some sector-specific ad tech regulation in the future, because ad tech is nothing else than a financial market. You have people who have an inventory, a commodity, and on the other side, you have people who want to buy them, and then you have an intermediary in the middle. So there might be a need, especially if the remedies are not sufficient, there might be a need for a regulation. But I don't think the DMA will be the answer. I'm more hopeful of the antitrust case in the EU and potentially of the code of conduct in the UK.
And Cloud, why the importance, this structural importance, strategic importance of this core platform service, and why the decision was made not to designate on this occasion anybody?
Well, I think cloud was a bit of a strange fish for the DMA, because if you think about it, the DMA is essentially trying to regulate intermediation services, right? Where you have a platform which have users on different sides. In the case of cloud computing, this is not really what it is, right? I mean, you have providers of cloud computing, and then you have companies using cloud computing, but there's no intermediation of any type. It's also different because it's effectively an oligopolistic market. You've got 4 or 5 players that are fairly large, fairly powerful companies. You have, the market leader Amazon, and then you have, I suppose, Microsoft, and then Google, and then a few others. So I think I never quite understood why cloud was part of the DMA. I'm not suggesting there are no problems with cloud. And as you know, you have investigations, but I'm not sure that the DMA was the right tool.
You mentioned the oligopolistic market, and I wanted in this context ask your view, what if the DMA will deliver mainly benefits, apart from most wise, proactive business users, to ecosystems themselves who will be using the opportunity, the DMA as a leverage to enter into each other's market, so-called inter-ecosystem competition.
Yes.
And it looks that it will trigger all the traditional benchmarks of what good competition appears to be from the traditional vision of antitrust, at least. Should we be neutral? Should we endorse? Should we be happy with this? Or should we somehow be skeptical, saying that we don't waste our public money for making them strong in different markets? How should we normatively evaluate this implication of the DMA?
No, I think I mean, obviously, some of the gatekeepers are well placed to take advantage of the DMA to enter markets in which you're not strong, right? Or to get a better deal with from other gatekeepers. But I don't think this is necessarily bad. More competition is more competition. And I don't think we should be selective in terms of who will compete. I think we should be neutral. So if the DMA allows Microsoft to better compete with Apple or with Google or with Amazon, well, I think that's fine. Obviously, we don't want competition to be limited to the big players. We want, of course, smaller players to be invited to the table. And I think this is what the DMA is trying to achieve. Now, we have to be realistic. To compete with giants, you typically need to have significant resources. And so this idea that a tiny company can suddenly compete with a gatekeeper is theoretically possible. And we have examples of small companies that grow very quickly because they offer a very interesting product. But generally, competition will come with existing companies that will be the best able to capitalize on the new opportunities.
We know that the UK bill is due to be approved and then received royal assent very soon. So there is little point in discussing this penultimate version in substance, even acknowledging that there are some very remarkable provisions in the bill and probably in the act itself. So maybe we'll reserve this opportunity, delayed opportunity for the next time. But I wanted to ask you a more sociological kind of question. You participated actively, commenting and contributing, submitting evidence in both regimes.
Yes.
We were developing it in parallel, but the pedigree, the background is rather different. What are your observations in terms of the benefits and shortcomings of both? What should we learn from each other? Is it even feasible to learn from each other from how the proposals materialize into positive law?
Right. I mean, I think generally experts prefer the UK regime because they will see benefits in terms of more flexibility. Whereas the DMA is effectively quite rigid, okay? So one of the benefits of the DMA is that it's up and running. For a long time, the UK was the leader. You remember the Furman report, and then everybody believed that the UK would be first, and there was a high level of excitement about it, and then they basically lost their way for all sorts of political reasons. So the DMA is up and running. It's something that is important. It didn't take many years to get it done. And so now we are expecting very soon the compliance program. So that's an advantage of the DMA. It was adopted really quite quickly and it was quite effective. Another benefit of the DMA is that it's quite clear. You've got a list of provisions, they need to be complied with. You can see with your eyes what the provisions are. You may not like some of them, but at least they are easy to identify, and I think there are merits in that in terms of legal certainty, for example. Now, the UK regime has a number of attractive features. As you know, designation will be made on the basis of the SMS test, which is a test that has already been applied in the past. So I think a test that is not based on strict numbers is generally better. I think the test for designation that was built in the DMA has the advantage of simplicity, right? Either you meet the thresholds or you don't. And if you do, you're designated. If you're not meeting the thresholds, you're not. Now, of course, it's only part of the story, right? It's not because you have lots of users, for example, that you're necessarily a problematic company. So that's a bit one of the weaknesses of the designation mechanism. I think SMS has, from that standpoint, probably more virtues. I think also that this idea of negotiating codes of conduct that are not necessarily limited to a strict list of provisions is also advantageous. So, for example, we're speaking about ad tech. I think the CMA will have probably greater ability to focus on the combination of problems that need to be addressed in order to have more competition in ad tech, whereas to some extent the Commission is constrained by the very limited provisions that are in the DMA. So I think that's another bonus of the DMCC regime. And then in terms of resources, the CMA has more resources than the European Commission, although it's only a country of nearly 70 million inhabitants. Here we've got fewer officials dealing with an entire continent. So there, again, the UK approach of sort of investing heavily in the DMU is, in my view, a plus. Now, we will see what happens with the DMCC and with the DMU, right? I mean, we haven't seen anything so far. So I think it will be, I think we will better be able to compare the two regimes and to assess their respective effectiveness a few years from now.
And also in terms of how receptive the both enforcers or co-legislators been to the voices of academia, third parties.
Yes.
Do you observe some differences between these two? Which one, whose radars were were better fine-tuned to listen the atmosphere, the overall mood, so to say, of the markets and other groups?
Yeah. So I mean, I think you know there are different traditions. As you know, the UK traditions is to do a lot of consultation. I had, for example, the opportunity to testify, I think, twice at the House of Lords. I've never been invited by anyone in the European Union to share my views on the DMA, although I'm actually Brussels-based and I probably know more about the EU system than I know with the UK one. So I think that the UK system has certainly allowed for more consultation from all parties, from academics, from practitioners, from the gatekeepers themselves. So yes, I think the UK system is generally more receptive to views from third parties than the EU one. Whether it will deliver better results in the end, we will see. But certainly there's been a large amount of consultation, and sometimes, you know, maybe there is too much consultation in the UK. The worst is Australia, where they keep consulting and writing reports instead of doing things, which I think is a bit problematic.
The new regime is also full of consultations. I would say, unfortunately, I think it's a little bit too, but it's too early to comment on this. Continue with this comparison. I know we're moving to the end of our conversation. What is your view? You teach simultaneously in the Netherlands, in Belgium, in the UK. How do you perceive the role? Yeah, and it's important to teach simultaneously. So it's not so temporal aspects are of less importance or impact. What is the difference between these three countries, and maybe you can extrapolate?
Well, first of all, I should disclose that I'm no longer doing any teaching at the moment because I'm just completely overwhelmed with what I'm doing. But I did quite a lot of teaching until a few years ago, indeed, sometimes the same year in the Netherlands and in the UK and even sometimes in the US. I think that generally academics have been very engaged with the process because it's a very interesting field. I mean, if you're a young academic now, I mean, it's a wonderful time because we're seeing the development of new regimes, and you can see their evolution from the very start. So it's super exciting, and I'm very glad to see a lot of young academics that are really doing excellent work. And I don't really see a big difference between those that are acting in Europe and those in the UK, for example, because the truth of the matter is that you've got very many continental lawyers teaching in UK universities. And very often they will look at both regimes at the same time. So yeah, I've seen perhaps a little bit more on the DMA than on the DMCC, but it's simply because, in fact, the DMA will apply to 27 countries, and so the number of jurisdictions concerned is larger, and you obviously benefit from having commentaries coming from France, Germany, the Netherlands, Belgium, Sweden, and so on. But generally, I think there's a lot of very good work that is being done across jurisdictions.
And moving to this recommendation, among other your incarnations, you're also co-editor of one of the most impactful journals, Journal of Competition Law and Economics, long-standing and continuous, and you are still, I hope.
Yes, I'm
so
still involved. Yeah.
And also you a founding partner of your boutique law firm, which continues growing. So maybe you can somehow, when designing your recommendation to students, we can somehow project about what you consider among the key features of successful applicants to enroll, to start working in this direction.
Yeah, I mean, look, I think you have different personalities and different tastes. So it's difficult to make useful recommendations. Now, what I noticed, and it's been my personal case, you can evolve over time, right? So when I started, I was a pure academic. I did a PhD. I spent 10 years of my life focusing 100% on university. And then I got involved in private practice because in a field like competition at the time, you know, the digital was really not a subject. But I thought, look, it's very nice to speak about cases, but it would be also nice to do one. It's nice to comment on general court judgments and Court of Justice decisions, but it would be nice to appear once. And then one thing leads to another, and then I really enjoyed the practical aspects of competition law and regulation. And over time, I became more and more of a practitioner and less of an academic, except for what I like to do, which is to write papers. So I've kept doing that with the same intensity. I think one thing that is really interesting about private practice in my field, unlike perhaps other fields, is that you do a lot of research. So when you have a case, you do a lot of research. You have to understand the products and the services. If you do tech work, you need to understand all the technicalities. And then you will, of course, research the law, research the economics. So it's very heavily research-based. And in fact, I spend probably half of my time doing research, really trying to find solutions to problems and trying to be creative in the way of handling problems. And in a way, you may do more research in private practice than at university sometimes, because at university, as you know, you have teaching commitments, and then there are committees, and universities are good at squeezing every drop of blood from the faculty. So if you're really research-minded, you should not make too much of a difference between academia and private practice, with one caveat, is that, of course, as a practitioner, you will have biases because you're involved in your cases and you strongly believe in what you do. Whereas in fact, as an academic, you should have more distance. Although, if you look at academics, people tend to take very strong positions, right? I mean, if you look in digital, there are some people who say there are no problems and these legislations are very bad and we should leave it to the market, and others that want always more intervention and more regulation. It may not be biases linked to clients or money, but these are still biases. But I mean, look, if you generally what I recommend people to do is to do what they like and to work hard. There's no miracle. If I look at my colleagues who have succeeded in academia and in private practice, there is a common a thread, which is that they work very, very hard. First, because this is what they like to do, and secondly, because this is a time-consuming activity. The sort of the output of competition authorities and courts is massive, and almost every day there is something that you need to look at, something new, and clients or contacts very often want your view on it. So it's a very time-consuming profession, I'm afraid.
Damien Geradin, thank you very much indeed for these illuminating thoughts.
Well, thank you so much for having me.